My name is Karen Edwards and I am a commercial solicitor here at Frettons. Today I'm just going to cover a short note about shareholders agreements. It is a very comprehensive area of law, but I just want to cover the main points that you should consider when putting a shareholders agreement in place. Just as a brief kind of introduction to the topic, shareholders agreements are used by and large to regulate the relationship between shareholders in a company and to set out how certain decisions and voting rights, etc., to kind of be managed. I think often is the case that people, particularly family-run businesses, think that there aren't going to be any disputes in the future. Unfortunately, we do see cases where disputes arise, and with a shareholders agreement in place, it's much easier to negotiate and resolve that dispute. So it's best to kind of have those points agreed from the outset. Without a shareholders agreement in place, you would be relying on the provisions of the Companies Act 2006. And whilst again that is an extremely comprehensive piece of legislation, it won't always cater for every eventuality. So just turning to the main topics then, just a brief run through really. Firstly, a shareholders agreement can deal with financing the company and what happens in relation to giving guarantees. So in terms of what happens if a shareholder makes a loan to the company, how would that be dealt with, how would it be repaid? What happens when shareholders guarantee liabilities and obligations of the company. Again, a shareholders agreement would set out how that would be dealt with. And also, in terms of the loan itself, if you don't have a provision which covers how that would be repaid, then the default position would be that the shareholders' loans would be repayable on demand. So again, it's important, as you would ordinarily put a loan agreement in place, it's important to have that one covered off. The next point is minority protection rights. Now, sometimes we might have a 50-50 split between director shareholders. Other times you're going to have minority shareholders who may just hold 5-10% shareholding in the company. What we do in shareholders agreements is put together a provision relating to the protection of those minority shareholders. And what I mean by that is what decisions can actually be made without their say-so, and what decisions requires a higher percentage so as to include those minority shareholders having to agree, or in fact unanimous consent. The ordinary decisions that can only be made with unanimous consent, i.e. with those minority shareholders' consent, are things like changing control of the company, changing how the company trades, getting rid of directors, that kind of thing. Without unanimous consent, or a higher percentage being required, without that provision in place, minority shareholders will find that decisions are being made without their say-so. Alternatively, you may also want to consider, particularly if you are a majority shareholder, what decisions you do and don't want them to have a say in, because obviously you don't want to give away too much control, and also you don't want to find yourself in a situation where director shareholders can't go about their daily running of a company because they have to keep reverting to a minority shareholder. So I think really it's a question of achieving the correct balance there. Another thing that shareholders agreements deal with is deadlock, and literally that means where a decision cannot be passed because you've got an equal number of voting on either side. Typically we find again that situation arising when we've got two directors and where they both hold 50% of the shares in the company. Now ideally, again, a shareholders agreement would be in place, and that would set out the procedure that needs to be followed in order to resolve that dispute. So rather than going down any formal route, it's encouraged for the parties to negotiate, and again there would be a procedure in place where they try to resolve their dispute. One serves notice on the other, a resolution notice, and they might want to use a third party in order to kind of mediate and get to a resolution. The shareholders agreement will set out what happens if that fails, and usually a procedure will be followed whereby one offers to buy the other person's shares or often offers to be bought out. Failing that, and obviously the shareholders agreement will set out that procedure in detail, failing that, it may be then that the parties agree that the company would be wound up. But again, having a correct, appropriate procedure in place avoids a situation of deadlock where there is literally no room at all for movement, and usually when we get to that stage and there isn't a correct procedure in place, we find that the relationship between the parties is untenable, and it's really very difficult to find a way of going forward. The next issue I want to cover is transferring shares. Now, sometimes the Articles of Association of a company will set out a procedure to be followed for transferring shares, but a shareholders agreement will go into far more detail. It allows the company to keep control to an extent of where shares go. So I'm talking here about when a shareholder decides that they want to exit the company. Now, the ordinary procedure that you would find adopted under a shareholders agreement will be where the shareholder offers their shares to the remaining shareholders. So there's a right of preemption, a first right of refusal in favour of the continuing shareholders to buy that shareholder out. Failing that, i.e. if those shareholders don't want to buy those shares, the company may then have a right of preemption. In fact, this is the usual procedure, so the company can buy those shares back. So again, keeping control back. Lastly, it may be then that the shareholder, the outgoing shareholder, has a right to sell to a third party, and that is usually caveated by the company having to give the prior consent of approval of that third party to come in. So again, we're not talking here about an outgoing shareholder literally being able to sell to whoever they want to, somebody that may actually in fact be a competitor or not really too interested in the actual running of the company itself. So again, important to have those correct transfer of share provisions in place, and also the shareholders agreement can talk about fair value as well. How are shares actually going to be valued? Are we going to apply a premium if somebody's got a huge, a large majority shareholding? Are we going to apply a discount if they've only got a minority shareholding? What's fair in that case? Penultimately is deemed transfer provisions, and this is where, if a certain situation arises, it is deemed that shareholder has to sell their shares. And I'm talking here about bankruptcy, death, if the shareholder has been unable to work due to incapacity, not being very well for example, 180 consecutive days in a year, or in fact if they cease to be a director. What you don't want is somebody leaving and no longer being a director but still retaining a control in the company. They obviously may not be interested in how the company is run anymore, their heart is somewhere else, but they still have control and ownership in the company. Interestingly here actually, I will just raise very briefly cross-option agreements, and again it's just a side topic, not something that I will discuss today, but if you do want more detail, obviously we can chat after this. But cross-option agreements deal with what happens to shares where they're automatically inherited into one's estate. The company may want to get those shares back, and a cross-option agreement allows for the company to be able to claw those shares back from the estate following death of the shareholder. And just going back again to the value of shares, again, if a director leaves on bad terms, if they're deemed a bad leaver, i.e. they're sacked for gross misconduct, for example, the company may want to consider again how much value they give to the shares of that outgoing shareholder. Finally, want to cover what we call tag and drag along rights. This is where a third party approaches the shareholders of a company and wants to buy shares. Well, again, if you don't have tag and drag along rights in place, what you might find if you're a majority shareholder is that a third party comes along with an extremely attractive offer for your shares, but unfortunately there's some minority shareholders who don't want to sell up. Well, you can't force a minority shareholder to sell their shares, or any shareholder in fact, unless they want to. If you have drag-along rights in place, you can essentially drag that minority shareholder along, so force them to sell their shares, and we can have certain provisions in place which allow you to do that if a third party is offering us a certain amount for the shares, or in fact if they're offering at all. And on the reverse side of that, you have tag-along rights, which allows a minority shareholder to kind of piggyback onto the offer made by the majority shareholder and force the majority shareholder only to accept an offer if the entire issued share capital is being purchased, i.e. that includes the minority shareholders' rights to, shares too, sorry. If you don't have these in place, and again you might find as a minority shareholder that you're left behind, the majority of the shares have been sold to a third party who you have no interest in dealing with at all. Conversely, if you're a majority shareholder, you'll find that you've got a really attractive offer in place, which means that you can realise the value in your investment, but you can't because the minority shareholder's holding you back. So they are just some of them, sorry to rattle through, they are some of the main points of a shareholders agreement. Obviously it's an extremely comprehensive document that we draft in order to make sure that all of those provisions and more are covered. It's extremely important that you do have a shareholders agreement in place to ensure that all of these issues are covered off, and actually it means that the shareholders can work together knowing that there is something already in place and these issues, is going to avoid dispute in the future, and they'll know in the comfort of knowing that these issues are dealt with. If you want to discuss any more, then my name is Karen Edwards. If you'd like to ring our reception team, I'd be happy to advise you further. Thank you for listening.